to the topic at hand, which is customary marriages. We have a level of complexity when we're looking at marriage in this country, and it is something that not everybody is able to take into account, either because they don't know or they don't understand. But Paula and Vuyo are here to explain to us exactly what you really do need to think about when you start the process of entering into a customary marriage and all the way through to the very end. So, Vuyo, would you like to kick us off as to why we should start thinking about what to do with a customary marriage?
Okay, thank you, Caitlin. We know that South Africa comes from, before our democracy, basically. So marriage between Black people, basically there was no piece of statute that regulated marriages between Black people. So post 1998, we never used to have a piece of legislation that said you need to follow these types of regulations. So customary marriages are regulated by the Recognition of Customary Marriages Act, which states that if you want to get married, in terms of custom, then you need to register your marriage with Home Affairs. So basically, there are 3 requirements that each couple needs to be cognizant of if they want to get married in terms of customary law. And that is requirement number 1, that the parties need to be 18 years or older. Requirement number 2 is that the parties who want to enter into the marriage need to consent to the marriage. And number 3, the marriage must be entered into or negotiated in terms of customary law.
Ah, that's very interesting. And I think that's something that not everybody really thinks about, actually, if they're going to undertake it, that there are these requirements. So I think it's very handy that we now have this available. And that, of course, is unpacked in the Recognition of Customary Marriages Act that is available online. In fact, we have it on our website. We've got an article that deals with this. And Paula, I think it's time for us to ask you some questions. In terms of those negotiations where you start the beginnings of the process for customary marriage, can you tell us a little bit more about that?
There is a letter exchange between the parties on a specific date. Upon that meeting of the minds, what happens is that the families would then conclude an amount in which they would like for lobola to be paid. Now, we refer to that as cows, dikgomo, which is the money element of it. They would set a stipulated amount, and if there is like for lack of a better word, I'll say like a deposit, because traditionally we believe that in any African marriages, the lobola of a woman is never finished or finalized. So they would then deposit the first, the first amount, and then they would then decide on a date again, wherein they would finalize the marriage. This is where then the exchange of gifts would come in. There would be like slaughtering of 2 animals. This is to welcome both the husband and wife into their respective families. And normally there is a list between the parties in terms of what they would require to be gifted. Normally these are blankets, and the family of the wife would then gift her with, I'd say, a starter pack on how to start off her new life as a married woman. That could be kitchen utensils, curtains, whatever that you may deem fit to start off your life as a newly married couple.
Yeah, that's fascinating, because I think a lot of us don't necessarily, a lot of us who don't necessarily come from that background don't necessarily understand the significance of lobola, and the fact that it's not, when we hear the phrase bride price, we often think that it's something that is finite. And the fact that you've explained that it's not actually ever really finished is something that does need to be examined. I see we have a hand. Sipamandla Nkuntai, can you put your question in a chat, if possible, and then we will read it out. The next point on this is sadly the sort of dissolution of marriages and the ending of customary marriage. And we had a question from Mr. TJ Majane. So if you are around, this is our little heads up to you that this is where your question is being addressed, because you emailed us beforehand. So thank you very much for participating that way, and asked about specifically divorcing within a customary marriage. So this bit is the bit for you. So Paula and Vuyo together, I think you can probably give us a blow-by-blow as to how one divorces with a customary marriage.
Okay, let me jump in there. So before we get to divorce, right? So I mentioned those three requirements in order to validate basically a customary marriage. So what the attendees need to know is that sorry, I just lost my train of thought. So what the attendees need to know is that non-registration of a customary marriage does not render it invalid, right? So then if, the marriage that you have entered into meet those requirements, then it means your marriage is valid. But however, you need to register your marriage with Home Affairs within 3 months after, the customary marriage or the ceremony that, Paula touched on there. And so if you have entered into that marriage and it is valid, then to divorce, you need to apply through our courts. Sorry, I don't know why I'm so nervous tonight. You need to apply through our courts as if you were married in terms of our marriage laws, right? So you need to issue divorce summons. You need to apply to the court to dissolve your marriage. So I know that our people, what they usually do is that because they did not register their marriage, they think that they do not have to divorce. So they would then just separate. And that is just not the correct way to go about it.
Because that's something that can cause confusion or problems later, particularly
absolutely
after either somebody has passed away or there is that question of divorce and remarriage. Yeah. And I'm going to open the floor to the questions that have been asked. Let's just have a squiz there, although I suspect that he has left. No, Supermandla seems to have left. And there is no one else with their hand up. So I'm afraid my connection froze when we were discussing the press, the case that was in the press. But I think there's a lot of incredibly informative discussions that can be had around this topic because, as you said, there was no recognition of the fact that these customary marriages had their own very intricate laws and very intricate rules that had to be abided by in order for them to be legitimate. And it's incredibly important that the more we discuss these different rules, that the less chance there is of anybody who's then going to fall victim because they did not necessarily understand the complexities around where the intricacies of customary marriage meet the letter of the law. And that's something that is one of our consistent goals here at Legal&Tax, is to ensure that we are that companion. And I hope that this is one of the ways that we can be a companion, even if load shedding is trying very hard to interfere with that drive. Supermanda's back. Supermanda, I'm going to offer you the opportunity to ask your question. So you are up now.
His mic is on mute.
That's...
but he has typed it in, Kate.
Oh, is he there? There we go.
Yeah.
Right. Vuyo, would you like to take that?
Sure. So Sipamanta's question is, he wants to know about basically the matrimonial regime that applies to customary marriages. So he wants to know if a customary marriage is in or out of community of property. So obviously before the act, a traditional or customary marriage was considered to be out of community of property. But after the act, after 1998, all marriages in South Africa, whether you are married in terms of custom, you are in a civil union, or you are in a traditional marriage, that marriage would then fall and will be, well, the matrimonial regime that applies, the default matrimonial regime that applies is a marriage in community of property. So what that means is that all your assets, all your liabilities that you had before your marriage, you are now sharing between each other. So it means you are now going to have a joint estate. And if this marriage is dissolved, then it means you guys have an equal share, 50-50 as it's informally referred to. If you want your marriage, your marriage to be out of community of property, then you would have to enter into an anti-nuptial contract. Most people know it as a prenup. You have to enter into an anti-nuptial contract that has to be registered with the deeds office, just to ensure that you are getting married out of community of property.
That's fascinating. And that is across the different matrimonial regimes as well. I think maybe we should unpack different matrimonial regimes available under our constitution a little bit. Who feels like taking that aspect of it?
I will take that question, Kate.
Thanks,
So
Paula.
we have three marital, you're welcome. We have three marital regimes, which is the first one is a marriage in community of property. This is where you jointly share any assets or liabilities within the marriage. And then we have a marriage in community of property. In community of property without accrual. Now, without accrual means that whatever assets that parties have prior to the marriage will not form part of the joint estate upon dissolution of the marriage. And then the last one would be a marriage out of community of property with the accrual system, meaning that whatever that has been acquired in the joint marriage, or rather from the beginning or substance of the marriage until the end of the marriage, will be shared in between the parties. However, there was a bit of contention this year. There was a matter heard in the Pretoria High Court, wherein a judge declared Section 7, subsection 3A of the Divorce Act unconstitutional, that it is quite unfair for women not to share in the accrual of the estate. This matter has been now referred to the Constitutional Court, just to unpack in terms of I'd say the two last marital regimes, that is me excluding the marriage in community of property, because that is quite straightforward. The court will look at the number of years that the parties have been living together, and everything will be shared in equally. Now, with the last two, that is what now the court are just trying to focus on, to see that no party benefits more than the other.
That's fascinating. And that's quite a nice step for womankind, as it were, at that point, because there was also the amendment to the Recognition of Customary Marriages Acts. The last one was that in 2021.
Yeah.
Which gave women the slightly more recognition under that act. Can you maybe unpack that for me a little bit? I don't think I have all the facts.
All right, so I think the case that you're referring to would be the Lerato Singardi versus the Tumble family case. Mainly people would know this as the double HP case, wherein double HP and the wife had, there was a lobola celebration between the parties. Upon his untimely death, the family of double HP contested that he was married to Lerato under customary rights. Whereas in terms of the Tswana custom, there was a formal handover of the bride. So in the Tswana custom, what we believe in is that, because I am Tswana, I can relate to this, is that once lobola has been fully paid, your family will formally hand you over to your husband's family. That's when you will be gifted with a blanket, which normally you cover your shoulders with whenever to go visit your in-laws. That shows a sign of respect, as well as a duk. So now it was quite a huge bone of contention that the father of the late was contesting that never occurred. So by miracle, Lerato had photographs to show that there was this formal handing over, there was a formal celebration held. And that's when then the judge ruled that she was actually the lawful wife of the late double HP, and she was able to share in the estate of double HP.
That is fascinating. And what were you saying, Vuyo?
Also just add this, sorry to interject, can I just also add, there's also been recent developments in our customary law. Earlier I mentioned that if you were married before 98, then it meant that your marriage would then still be out of community of property, right? So there's recent case law that basically states that even if you were married before 1998, now as a woman, you have now patrimonial rights in your marriage, which means that you can also claim 50% of the joint estate.
That's fascinating. And I think that's also something that a lot of people maybe didn't realize before. I think we'll take a couple of questions. We've had some very, very patient attendees. We have from Beko Matendra. So what happens if you want a second wife?
So I think his question,
sorry.
sorry about that, Vuyo. May I please take this one?
Sure.
I think his question is quite open-ended. I'll just answer this in terms of the customary marriage side of things. So now, in terms of the customary law, you would need to get permission from your wife to take a second wife. The practice now, there is a show that on TV that just shows certain male figures just bombarding their wives and demanding to take a second wife. But traditionally, permission should be granted by the first wife, who we mainly refer to as umamkulu. That is the respect that is bestowed upon the first wife, because you would need to explain to your first wife why you would like to take a second wife. Is it to grow the family, or it could be that the first wife could not bear you any children, and this would also need to be discussed with both families, and that some form of agreement would be reached. I know, and I've read on, in terms of some Zulu cultures, it is believed that you would need to also get the permission of your wife's family before you embark on that journey, so that it creates a very holistic and happy marriage, so that your first wife does not feel like she is useless in the marriage, and that there is somewhat of value that she is adding in the marriage.
Can I also just add there to what my colleague Paula had said. So if you intend on the onset that you want more than one wife, then you need to make sure that you enter into a customary marriage and not go to Home Affairs, sign and enter into a traditional marriage. So this means that firstly, you enter into a customary marriage because it is the only marriage that allows you to take a second wife. So let's say, for example, you are already married in terms of civil law with your spouse, and now you want to enter into, you want to take a second wife. Then it means you have to firstly dissolve the first marriage that is in terms of civil law, and then you have to register a customary marriage with your first wife in order for you to take on a second wife.
So quite complex. There is a lot to think about and a lot to unpack. And I can see that there are two questions, one from Anonymous and one from Antoinette, discussing about the time in which you can cohabit with someone before they are. Actually, no, I lie. The anonymous question is the one about the cohabitation with a partner after it is determined that you are married in a community of property. Is this accurate?
No. So I think where we seem to miss it as a community is that if you are in for lack of a better word, we don't call them a cohabitation agreement or partnership. It's called a universal life partnership. Now, what the law requires is that if you are in a universal life partnership and you would like to bequeath a few things to your partner, you enter into a universal partnership life agreement wherein you both state what each party should bequeath or benefit from each other should you pass on. But the main thing with a universal life partnership is that it should be to the benefit of both parties. One cannot benefit more than the other. Now, it doesn't mean that when you're in a universal life partnership, you guys are automatically married. It is not like that. However, now what the courts have done is that if you have been in a universal life partnership for more than 10 years or 5 years, you would need to prove certain things. Maybe you guys were sharing the rent. Maybe you have a child together and you were paying school fees. You need to prove quite a lot of things. If there was an agreement in place, those are the things that you need to bring into account. And then if you need to claim against the deceased estate, that is the things that then you would provide to the Master of the High Court's office to show that you were in a universal life partnership with your significant other, and that you would need maybe like maintenance if you're unemployed. Because remember, with marriages or universal life partnership, it's not only monetary value that somebody would bring. Still being like a stay-at-home mom, cooking, making sure that the house is well kept, you being a home executive, as I'd like to call it, you're still adding a lot of value into that partnership. So it does not mean that when you're cohabiting with somebody, you are legally married.
No.
So it's not accurate, anonymous attending. I hope that this answers your question. I'm not sure if Vuyo would like to also unpack on it.
No. You said all there is perfectly.
Awesome.
So we were supposed to finish at 6:30, but anybody who is still keen to have their questions answered, I think we'll try and answer a few more. Otherwise, we'll make sure that we actually do get a hold of your email addresses. We'll be able to get them from the webinar invites and then actually send you some answers to your questions, because there's some really interesting ones here. I see Siyabonga, David and Kize. Good evening, ladies. My name is Siyabonga and Kize. I just want to know, is it possible to register a customary marriage even though your partner is late? She was admitted to hospital before we could even register our customary marriage and she passed on. Lobola was paid in full and we even got engaged. So how do I go about registering it?
Yes, Siyabonga, it is possible. You have to bring an application to the High Court. But obviously, remember, the party who alleges must prove. You need to prove that indeed there was a customary marriage. So the people who attended your lobola or your lobola negotiations or the wedding can provide, witness statements to that fact. So basically, you need to prove to the court that there was a marriage, and then they would then register it. Or give a direct instruction to the Master of the High Court or Home Affairs to register that marriage so that you can then, claim the assets or whatever the case may be.
Thank you, Vuyo. And then there is another question from Shadrach Nkonto, and I know that you put your hand up at the very beginning and then we lost our connectivity, so thank you for being patient. And your question says, I first married in a community of property to my ex-wife, whom I was married to for 37 years. I divorced 7 years ago and I got married to 2 wives now. And in capitals, I am a polygamist. Now I paid lobola to both of them. What then?
All right. Shadrach, it's quite clear what then in terms of what? The family lifestyle or you providing a will? Automatically, if there is no will, I'm assuming maybe you're asking about that should something happen to you, how your estate will then be run would be interstate succession, meaning that you did not leave like any documented way in which you'd like your assets to be dissolved. However, then the first wife in this instant will be then taken as, I'd say, the head of the family, who would then inform your other wife. I'm assuming you will probably maybe take more wives, so I'll say your other wives, of what should happen to the estate. But ideally, I would advise that you do have a will drawn with your legal eagles, and then they can assist you further in case that something does happen to you. But I hope you could just provide a bit of clarity in terms of your what then, so that we can give you a clear answer. Thank you for your question.
And thank you, Paula. And there's another very interesting question from Zubaida George. And she's, apologies if I got the pronoun wrong there. And they're asking if this applies to Muslim marriage as well.
What applies to Muslim marriages, like the customs? Because remember that with Muslim marriages, they have their own act that governs their own marriages. So it's in terms of the Muslims Act, I think I'm subject to correction, but remember they would marry in terms of that act as well as home affairs. So okay. I do, when I was still in practice, I did have a client of mine who was married under both Muslim rights and then in terms of a civil union, which is when they signed at Home Affairs. They were divorced in accordance to our civil laws, which is they did get a decree of divorce. But in terms of the Islam laws, they still are deemed husband and wife. So I just need Zubaida to just give us clarity. So, it would still, it's not that it's in community of property, because if you're married under Islam laws and then there is a civil union, either parties could have an anti-nuptial contract with or without accrual, or that the marriage is in community of property, and then they would, upon dissolution of the marriage, they would each share in 50% of each other's assets and liabilities.
That's fascinating.
Can I just add there? I think with religious marriages, our laws are not still quite clear. According to my understanding, is that if you are married in terms of religious rights, then you'd also have to get married or enter into a civil union in order to share the patrimonial rights as a woman with your husband.
Okay. It seems very much as though there's a very distinct protection that is granted by the Constitution in terms of recognizing religious and so any kind of marriage ceremony that it wasn't necessarily done at home affairs, but there is protection that is allowed for those specific ceremonies within their traditions and within their heritage. And obviously that is the theme of the webinar series, is within cultures and throughout our heritages. And I think the main theme that seems to come up from that is that there must always be proof of what happened and whether or not it took place in accordance with the laws and the traditions that govern it based on the culture in which it is taking place. And I think that seems to be the common thread to me. Zobeda did just say in community of property. And she says, thank you. So thank you, Zobeda. I'm glad we answered your question. And then we might sadly have to wrap this up, but there was a follow-up from Ngobeko. Said, is it legally binding that the first wife should agree to getting a new wife? So
no.
Ideally, yes.
Yeah.
I mean, you would not want your wives to be fighting, over the hierarchy of, who would be deemed the first wife in the marriage relationship. So to have a harmonious relationship or marriage in this instance,
yes,
I would recommend you get permission.
There are three nodding heads that are going.
Yes, even though it's not a legal requirement, it is strongly recommended that you do get your first wife's permission.
We suggest. We suggest that you get your first wife's permission. So we have gone 7 minutes over time. So I am now going to call this to a close, but I'm going to keep a record of the questions that are still here. Actually, just before one, there's a very interesting question from Feliciwe Dlamini. If you are married, civil marriage, and your husband falls under debt review or something of that sort, then you as a wife, do you also automatically go under debt review or blacklisted, like you also can't purchase anything online?
Okay, so it would depend what matrimonial regime applies to your marriage. So if you are married in community of property, remember you have a joint estate, right? So you share all the goods and bads of your marriage. So if your husband goes out there without your permission and takes some debt, for example, you are then also liable. So your husband's creditors are creditors of the joint estate. So if they cannot claim from your spouse, then they can claim from you. So if he's under debt review, it means the joint estate is under debt review. So that's why you should be very careful. I suggest, so this is what I always advise people, is that if you intend to marry someone, do a credit check, or just make sure that they are good with money, or they don't have very bad spending habits. So yes, you have a joint estate, and thus you are automatically also under debt review.
Okay. So it is something to take into consideration when one is planning to get married or continuing to stay in a marriage. And I think that is a very, very difficult road to navigate when one has the pressure of family and one has the societal pressures of what happens if I get divorced, or what happens if I leave this person, because obviously one has built a life together, and when that life comes under debt review, I imagine that must be quite difficult. So I'd like to thank all of you. This has been a very, very interesting webinar, and thank you so much for asking such interesting questions. I'm going to make sure that this webinar, that the recording is available online. It's going to be up on YouTube and then on our website as well. And we will send a link to everybody who registered to say, A, thank you for registering, and B, here is the on-demand link for the recording. And if you missed anything, please feel free to drop us an email we'll be able to respond to emails that come in on our website, so through info@legal&tax.co.za. And you're also more than welcome to leave a comment and a like on our Facebook page. I'm afraid our Facebook streaming didn't cope with the load shedding. So, but we will be posting links to the chapters of our webinar throughout the rest of the month. And we will be hosting another webinar next week, same time, hopefully not with Eskom. We'll be hosting a very interesting webinar on the culture of credit and how much is too much with Mokgadi Sabalelo. And it'll be fantastic to get some participation like we had today. So thank you again, and we're going to say goodbye. And we say thank you very much to Paula Thekiso-Mahlangu and to Vuyokazi Mpela, our admitted
Thank you,
paralegals.
everyone. Thank you. Good night.
Cheers.
Cheers.